but we want to welcome you today to AB5 in the Arts. We're thrilled to welcome you all and have you here to get some great questions answered and learn a little bit more about the recent legal changes at the state level. So my name is Tom DeCaney. I'm our Executive Director at the California Alliance for Arts Education, and thank you so much for being here today. As our slide states, we'd like to have you place your name and role or organization in the chat box. That just gives us a better sense of who's joining us today. It looks like a really incredible group from around the state of California, from a lot of great organizations. So thank you so much for joining us. I want to start by thanking the Walter and Elise Haas Fund, who made this work possible. They were very generous as a supporter of the California Alliance for Arts Education and supporting our work to help get in alignment with AB5. And we wanted to share some of the lessons we learned through that process with you today through our partnership with our legal counsel, Arlene Yang. So before I do that, I also want to thank our co-sponsor today, Californians for the Arts, and their director, Julie Baker, and for their ongoing partnership. And we're going to drop in the chat here a link to Californians for the Arts upcoming events. So they have a number of regional events around the state. We encourage you to check out the link and to check out some of their events. And we want to, again, thank them for their ongoing partnership and our work to advance the arts education in the state of California. Next, just a couple of housekeeping notes. I wanted to let everyone know that we are recording today. The whole session will be recorded, and we will be sending it out to the entire group. So if there's any information here on any of the slides, no worries. We'll be sure to send you the recording afterwards so you can go back and catch anything you may have missed. So, and then just to remind you that we will be recording. And also, finally, we welcome you to use the Q&A feature at the bottom of the webinar. If you add a question in there, we will work to get as many questions as we can answered. And we want to thank everybody for all the incredible questions we received in the registration process. So we have a very long list of questions, and I can already tell you that unfortunately we're not going to get to all of them, but we've tried to pick out some that might be relevant to the largest number of attendees today. And then happy to direct folks to resources to get your questions answered going forward. So with that, I want to hand it over to my colleague, Adelaide Kuhn, who's our program director at the California Alliance for Arts Education, to lead us through a land acknowledgement. Adelaide?
Thanks, Tom. Hi, everyone. So great to be here with you today. I would like to take a moment to open our discussion with an acknowledgement of the land we stand on. I am joining the conversation today from Los Angeles, California, which is the unceded territory of the Tongva people. I want to acknowledge that for centuries, Indigenous people have maintained stewardship over the land that we are on and continue to do so today. I want to acknowledge that for centuries, I acknowledge that the land of the Tongva people, acknowledging the land of the Tongva people is a way to shift power by remembering and honoring the historical truth of the violence and oppression of colonialism. You'll see on the slide right now, there are two ways to access the tool called Native Land. Native Land maps Indigenous territories, treaties, and languages. It's a broadly researched, crowdsourced body of information, and it is meant to encourage engagement and education on topics of Indigenous land, primarily where they are located. So please, I'll ask you now to take a moment to access this tool either via the link in the chat or using your cell phone, texting this phone number. And please put in your address, your home or work, wherever you are now, and use the tool to identify the names of the tribes whose land was colonized where you are right now. And once you find that information, I then welcome you to share your acknowledgement of the land in the chat box. So I'll give you everybody a moment to do that. Thank you so much, everyone. And you please feel free to continue to put that information in the chat. I want to close by just encouraging every participant to consider their personal responsibility to the people and land where you are right now, and to take action to stand in solidarity with Native, Indigenous, and First Nations people, working to actively disrupt structures of oppression that reproduce ongoing colonial relations of violence and power. Thank you all so much for taking the time to do that. I now pass things back to you, Tom.
Great. Thank you so much, Adelaide, and thank you for everybody for sharing and taking time for this land acknowledgement. And with that, it's my great pleasure to introduce Arlene Yang, who we've had the pleasure of working with for this past year, again, thanks to the Walter Nolise Haas Fund's generous support. And Arlene has taught us a lot about AB 5 and how we can be in better compliance with California's labor laws. And with that, I'm going to hand it over to Arlene.
Great, thank you, Tom. So welcome, everyone. My name again is Arlene Yang. I'm a principal at Meyers Nave, and I focus on helping employers to navigate the complexities of employment law with advice and counsel, workplace investigations, and also litigation. I also have a special passion for arts organizations. I'm currently the board president of Transcendence Youth Arts Project, which is a creative youth development organization based here in San Diego. And I also spent many years as a fundraiser and grant writer for theater companies in New York City. So I really understand the struggles of smaller nonprofit arts organizations and the struggles in complying with these new laws. So now that if we can go to the next slide. Because I am a lawyer, I want to just give you a little bit of a disclaimer. This is just legal information for you. It's not intended to be forming an attorney-client relationship or providing you with legal advice. So if you have particular problems, I encourage you to talk to an attorney. And now that you've heard a little bit about me, we can go through the agenda. And we also have some poll questions, I believe. And so let's start with that. And while we're getting the answers, I can tell you what the agenda is. So our first question is, how many workers, employees, or independent contractors does your organization have? And then while we're getting the answer to that, I'm just going to tell you a little bit about what we're going to be talking about today. We're going to kind of set the stage looking at arts workers as independent contractors from the big picture issues, comparing some of the protections between employees and independent contractors. And then I'm going to spend some time talking about AB 5, AB 2257, which was an amendment to AB 5, and then also Prop 22. To go through that in some detail, then go through some of your questions and practical advice that we've received from questions already. And then we also have time for you to ask questions at the end, or feel free to put them in the Q&A while we're going through. So here we have 26% of the participants have about 11 to 24 people in their organization, and with the other ones spread out. So it's a pretty even mix. I think we have one more poll question too. And that is whether you are attending as a representative of the organization's management, as a worker, as an independent contractor, as someone who's an employee, or none of the above. And you can select multiple choices. So as we're waiting for the answers, I think I can keep moving on if we can go to the next slide. So one thing that I did want to point out to you is there was in January a study released on arts workers in California. And it was put out by the Urban Institute and funded by the Hewlett Foundation. And I would really encourage you to take a look at this study. It has a lot of interesting data where they've taken a deep dive to look at what's going on nationally with arts workers and independent contractors. Okay, here's our poll results. We have 80% are here representing organization management. And then we also have some people who are independent contractors and some people who are employees. So thank you. That's very helpful for us to get an understanding of who's here with us today. So generally looking at arts workers in California, we see that arts workers are more likely to be self-employed than in other parts of the country, and that so there's high percentage of arts workers are self-employed, and so that's an interesting thing to think about. So it's a large percentage of the people who are working in the arts are independent contractors. If we can go on to the next slide. One thing that we've seen, of course, in this past year has been the pandemic. And we see that the rate of unemployment is higher for arts workers. We see that in January and February of last year, it was pretty close. But then we saw when the pandemic hit, unemployment rose for arts workers at a greater rate than all other workers. And you see through September, that rate was still higher. So we see that the pandemic has hit arts workers more than the general population. Another thing that has come up is with this pandemic is really thinking about issues of equity. So we know that BIPOC communities have a higher rate of exposure and sickness from the COVID, and also higher rate of death. And then we also, especially with the killing of George Floyd last year, issues of racial equity have come into play. And part of that discussion really has to be thinking about pay practices and whether those pay practices are equitable. So I know that I'm involved with arts organizations, and these are the discussions that we've been having to make sure that employees or workers are being paid fairly, and how that affects or doesn't affect the racial demographics of your organization. So because we know that because people love the arts, often they'll take what probably would be a pay cut considering their level of education and experience in order to do the work. And can all parts of our society afford to do that if they don't have family members who can help to subsidize them? Those kind of issues come into play. And we see that during this pandemic, the differences between being an employee and an independent contractor has come into play. So we know that before the pandemic, if you're an independent contractor, you wouldn't be able to collect unemployment insurance, workers' compensation, unless you paid for it yourself. There were no employer contributions to Social Security and Medicare, no paid family leave or benefits like that. They were not available to independent contractors. And even though we saw with the pandemic, there was some pandemic unemployment insurance, those benefits were limited, and many artists that I've spoken with were left in the like kind of in a crack in between. If they had, for instance, a small amount of W-2 income and most of their income was as independent contractor, their benefits were based on how much W-2 income they had. So we see that really the systems were set up and the social safety net was designed to help employees and not independent contractors. Also, there are worker rights that are available to employees but not independent contractors, such as minimum wage, overtime, discrimination protections may not be as available, the right to unionize under the National Labor Relations Act. We have health and safety protections, paid sick leave, unpaid family leave, California Family Rights Act. These are all benefits that are available to employees but not independent contractors. And then of course the employers may have their own benefits that are only available to employees, such as health insurance or disability. So we see that there is a big difference between the benefits that an employee gets versus an independent contractor. But then of course that comes with a price. So we know that it can cost some estimates are 20 to 30% more to have an employee versus independent contractor. And that is quite a big, it can be a shock to the budget if there is, most organizations don't have the funds lying around that can bear that kind of expense. So Just to keep in mind though, that with this AB5, it's really not, the issue of misclassification of independent contractors is not a new issue. Some studies have shown, and this is before AB5, that 10 to 15% of independent contractors were actually misclassified under the old standards. And so I've worked with many organizations where things went on for many years, the employee may have been misclassified and no one complained, but then something happens. And then you realize that they're mistakes and that it's can be time consuming and expensive to clean it up. So for an instance, an example would be you have a dancer for a dance company, and the practice for many dance companies was to hire everyone as an independent contractor. Now someone gets injured on the job, they file a workers' compensation claim, then it can kind of dig up those issues, and so there may be liability for their medical expenses, and then possibly, you know, failure to pay for workers' compensation. There can be a lot of expenses that arise. Other situations that happen is sometimes there's someone who is a former worker and they file a claim with the labor commissioner claiming that they were an employee and not paid their back wages or something. That can dig up the issue again, or there could be an unemployment claim. There are many things that can happen. This can happen related to this misclassification of independent contractor issues, or sometimes other wage and hour issues as well. Things can go along for many years and then something happens. Usually it's an employee making a claim, and then it brings the issue to light. It's far less common to have the state just coming in and investigating for no reason. So we have our third poll question, which is, have you encountered a claim that an independent contractor was misclassified? And so we can go on to the next slide. All right, so most people have not, that's good for you. Most people have not encountered a claim that independent contractor was misclassified. 77%. Just to let you know, to give you a little bit of the scary part that might happen, there could be claims for unpaid overtime and minimum wage, missed meal periods or missed rest periods. Just as a tip, if you don't know this, if you have a non-exempt employee and they are unable to take their meal period or rest break, they're owed a 1 hour premium pay for each day that they miss the meal period or rest period. So it's very important to try to keep track of when someone's taking their meal period and ensuring that people have access to take the rest break. Just as an aside, there was just a California Supreme Court decision last week that said for missed meal periods that when you're tracking whether someone gets a 30-minute meal period, you have to track it to the minute. You can't round like up to the nearest 10 minutes or something like that. It has to be by the minute, and it could be a violation if you don't track it that way. So you want to take a look at those kind of little issues. It can add up. So there could also be claims for unreimbursed business expenses, improper wage statements. So there are a number of different kinds of things that can come up once someone makes a claim that they're misclassified. We can go on to the next slide. Oh, so we have another poll question. What are your biggest concerns about independent contractor issues? We don't have enough funds to pay for independent contractors as employees. Our independent contractors don't want to change to be employees. The administrative burden in managing many employees is too expensive. We think our independent contractors are properly classified, or if you have something else, put it in the chat. So let us know what you're worried about. And we have a comment saying getting insurance is expensive when they're temporary or specialty projects. So as we're getting that information, I'll just start to tell you a little bit about the history of how we got here. And so we have the for many years, the test was related to a simplified, so the test was called the Borell test, and that still applies in some cases, and that's based on a 1989 Supreme Court case. And that has a multi-factor test, and some of them it's 11 factors, some of it's more factors. And the most important one is who controls the way the work is done. Then okay, here we have our answers to our poll. The most common one was 57%. We don't have enough funds to pay our independent contractors and employees. And then we have a good number, 46%, saying independent contractors don't want to change, worried about the burden. We think our independent contractors are properly classified. So we've got a lot here. Some of the other ones that people have mentioned: unemployment, worry about paying unemployment insurance, and that you don't think the law should apply to mariachis. We have a lot of different concerns here. So I'm going to keep going forward, and we'll try to get to some of these issues as we go through the presentation. So anyway, we have Borell, which was this 1989 case, multi-factor test, and it's sort of a weighing case situation. So you could meet some factors and not other factors, and if you're more like an employee than an independent contractor, that's how the test would go. So there was a lot of ability to kind of fudge whether someone's make an argument that someone was an independent contractor. But then in 2018, we had this dynamics case from the California Supreme Court, which upended everything and had a new ABC test, which was much more simple and much harder to meet. So that got a lot of people's attention. Then what really got a lot of arts groups interested in this issue was AB 5, which was passed in 2019. And that codified the ABC test, so that made it law, and then it expanded it in some areas to more areas of the labor code and employment code. And then it also created some exemptions. And then AB 2257 was passed last year, and that kept AB 5 pretty much in place, but added some additional exemptions. And then we also had Prop 22. So I just want to talk a little bit about Prop 22, and then we can set it aside. Prop 22 was focused on app-based drivers. So that was Uber, Lyft, DoorDash. It doesn't really apply to any other people. So when we think about, for arts organizations, whether what laws we have to think about, we don't have to worry about Prop 22. So I wanted to just talk a little bit about a little fact scenario so we can kind of help us to think about what I would do if I were helping an organization to think about their independent contractor issues. We have Around the Block, an arts and education organization, hires Jessica Jump, a teaching artist specializing in painting, to teach students twice a week over 4 months. Jessica has her own business, which consists only of her, and she does not teach for other organizations. So Ken Around the Block hired Jessica as an independent contractor. So what we would do is start first with the ABC test. So if we go to the next slide, okay, we're getting some people saying no. We're going to start first with the ABC test. I think most of you have heard it by now. It's a 3-factor test. You have to meet each of the factors. So it's the employer has to show that the worker is free from the control and direction of the hiring entity in connection with the performance of the work under contract, and in fact, that the work is outside of the hiring entity's usual course of business, and that the contractor is customarily engaged in an independently established trade, occupation, or business. So that is the 3-part test. Well, if we could go back to that slide. So I just want to talk about that a little bit more. The part that is very difficult to meet often is performing work that is outside the hiring entity's course of business. So we have the situation where you have the dance company hiring dancers. They're in the same course of business. So it's very difficult then to meet the ABC test. The Dynamics case was a case where you had a delivery company and the driver sued. It's very difficult to say that they're outside of the usual course of the hiring entity's usual course of business. The most clear-cut case is something like the plumber. If the plumber is coming into the dance company, it's a different business. The dance company is not going to be telling them how to fix the toilet. So it passes the ABC test. So then we want to look then, if it doesn't pass the ABC test, let's look and see if there's any exemptions. So we go to the next slide, and that shows, this is sort of a summary of the exemptions. And I encourage you, if you think that you have an organization that may be eligible for one of the exemptions, take a look at AB 2257. You pretty much just have to type it in and then maybe legislature, and it'll show you the actual statute. And then it kind of runs you through these different exemptions. So the main types of exemptions are this bona fide business-to-business contracting relationship, referral agencies. This is a new exemption that was put into AB 2257. Contracts for professional services, certain other professions. There are some exemptions. A new provision in AB 2257 is relationships between two individuals. And then there are quite a number of music industry exemptions that were in AB 2257. So if you're in that industry, then I encourage you to really take a look to see if there might be something that applies. So we're going to go back, if we go to the next slide, we're going to look at the business service provider exemption. This is, and even with these exemptions, they're not necessarily very easy. Once you have to be a business service provider, then there's a 12-part test that has to be satisfied. And if that test is satisfied, you still have to meet the requirements of the Borell test. So it can still be difficult to really be classified as an independent contractor with some of these exemptions. So we're going to go through. I'm not going to read the whole thing, but you can take a look, and I think the slide should be available later. When we have this business service provider, that's generally someone who's incorporated or in some form or an LLC, and they have their own business. And then there are 12 parts. So they have to be free from the control and direction of the performance of the work under contract. And in fact, one that's difficult to meet, and it did change a little bit with AB 2257, is this requirement that the services are provided directly to the contracting business and not to the customers of the contracting business. So this can, for instance, we had this issue with this Jessica Jump. If she's teaching the student of the arts organization, that may make it difficult to meet this business service provider exemption. And it doesn't apply to if they perform solely in the name of the business and they provide regularly contracts with other businesses. So there may be a possibility, but you'd have to really get into the facts. So if we go into the next slide. So these are some more of the factors that need to be considered, requiring to have a business license. The contract has to be in writing, a separate location. All these are the requirements that are set forth in the statute. And if we go on to the next slide, so then we have some more of these other factors that need to be considered. And this is not a balancing test. The relationship has to meet all 12 of these factors. So it can be complex. So then, in addition to that 12-part test, if we go on to the next slide, then there's also this Borell test, that old test from 1989. And so here are a number of other factors that need to be considered. So I think it can be challenging. Right, so this is a ridiculously confusing test, and that's what one of our one of our attendees have said. So then that's the business service provider test. If we can go on to the next slide, right? So let's say it didn't meet that, then you would go on and say, well, maybe can we get an exemption as a referral agency? I'm not going to go into that in detail because it doesn't apply as much to our audience today. And then there's also contracts for professional services as an exemption. This has been one that might be helpful for arts organizations in terms of some of their functions, such as HR functions. Again, this is a situation where has to be providing professional services, and I'll talk about what that is. Then there's a 6-part test and then there's also the Borell test. So I'm going to just run through that quickly so you can see what that is. Some of the things that are considered professional services as defined in AB5 are things like freelance writers, HR administrators, marketing. One thing that's interesting is the fine arts definition. When AB5 was first passed, it just mentioned that there could be an exemption for fine artists, but it didn't define what they were. So AB 2257 provided a definition, and it's very close to what we would traditionally consider to be visual artists, fine artists, that type of definition. And then there's also requirements related to still photographers and photo editors. There have been limits regarding the numbers of photos that could be published, and some of those have changed. So I did want to mention that there is this new professional services category, which is a specialized performer hired by a performing arts company or organization to teach a master class for no more than 1 week. Once a week. And there's a definition of what the master class is. It's a specialized course for limited duration that's not regularly offered by the hiring entity and is taught by an expert in a recognized field of artistic endeavor who does not work for the hiring entity to teach on a regular basis. So that does seem to be what is traditionally considered to be a master class. So for instance, Transcendence will have some professional dancers coming from who happen to be performing in San Diego to come and teach a class to the students. That could be a master class. We did receive some questions asking, can we treat all of our classes as a master class? It seems unlikely if it could meet, if it can meet all these tests that it's only a limited duration, not more than once a week, maybe you can call it a professional service, but you'd have to, so a lot of these are very fact specific. So you have to decide what it means. Now, these are just the statute. We got a question about what does it mean if it's regularly offered? We don't have any litigation or regulations that tell us exactly what it means. So we're just kind of guessing based on what the word says, what the statute really means. Right, so we have then, so in addition to having to be a professional service, you also need to think about this 6-part test, and I've set forth the requirements. It's requiring a business license, that they have exercise discretion and independent judgment. And so we have, so there's that 6-part test, and then again, there's also the Borell test. So if we can go into the next slide. And so again, in that test, the key factor is who has the right to control what's being done. And I think that this does raise an issue regarding teaching artists who are working with students in terms of how much control really is, is it really that there's not much control by the organization, or is there some sort of curriculum or standards that the teaching artist has to be following? I think that this cause, it's a very fact-specific analysis that you need to think about. So that's professional services. Then there's other professions. We can talk a little bit about the relationships between two individuals. And that's going to be our next section. This is a new type of exemption, and it's where you have two individuals who are both sole proprietorships or business entities, and then they have contract for a single event, not more than once a week. And then there's also this 8-factor test. So you'd have to take a look through the statute and see if you can make it apply to your situation. So if we go to the next one, and then the final one is music industry exemptions. Because it's very, very detailed, I'm not going to go into too much detail for it, but there are a lot of rules related to producing musical recordings and compositions. And then there are also some rules regarding if it's a single engagement live performance. And if it's self-directed, it's not a concert venue or a festival. So I'm not going to go into great detail on this, but if there may be exemptions available under that. So that's kind of an overview of where we are. I wanted to see, I wanted to just review some of the questions that we've gotten, and we can take some more questions along the way. And I'm also counting on Tom to jump in because I haven't been able to monitor the chat. It seems like we have a very, very active chat group.
Yeah. Well,
so I will, but I wanted to talk about some of these basic questions that I have on the slide, and then we can go into other questions as well. So we had a number of questions about, are there exemptions if you're a small or a new organization? And unfortunately, the answer is no. So this applies to all employers. We have the situations about, there are questions about the challenges of dancers preferring to work with multiple companies. So we can't really control that right now. And we had a number of questions where people are having difficulty scheduling employment with multiple companies, but that's just the way, and there's nothing that we can do about that under the law. We have questions about whether if you have a 4-day festival or one-off event, the AB5 rules would still apply. And it would, if you're, the type of work that's being done is as an employee, then it doesn't really matter that it's just for temporary work. You do want to think about, some things that I do as an employment lawyer is I provide the advice and what the most safe position would be, the most risk adverse position. But sometimes employers will not follow my advice. They're willing to take the risk of taking some risk and doing something that may be a little bit different. So you have to think about what works best for your organization. So the cases that are most risky is if you have a long-term independent contractor and you're paying them a lot of money, so that if they were misclassified, their claim is going to be worth a lot more than if it was a very short-term and small amount of money. So you can think about that. And generally, another thing to think about is that for reporting for tax reporting as an independent contractor or employee, for a W-2, both of them have a $600, you have to earn at least $600. So that, there may be less documentation or tax reporting related to the issue if it's someone who's making a very small amount of money. We had some questions about stipends and per diem. And so one thing that is helpful for nonprofit organizations is that nonprofit organizations can have volunteers. Unlike some other states which allow volunteers for private companies, California does not. So if you have a private company, you can have people volunteering to work for you for free. But if you have a nonprofit, you can have volunteers. And it is permitted to provide stipends, like something like a travel stipend, if it's a small amount, or a gift card, but something that's not close at all to what you might pay someone if they were doing work. So there's still ability to have stipends for volunteers. Another question that we received was out-of-state workers. So these laws only apply to workers in California. So if you have someone who's working in Nevada, you don't have to follow AB5 and working for them. And I have heard employers, especially out-of-state employers saying, we don't want to hire anyone in California because of the regulations, unfortunately.
Great. Well, Arlene, maybe I'll jump in, and I just want to first kind of like collectively acknowledge the collective frustration. So I know in a lot of the chat, people are experiencing the frustration, and I just want to share my own frustration as somebody who thinks I'm fairly savvy with law, and AB5 certainly is not simple. So I think I just want to acknowledge those that are feeling frustrated by the lack of clarity and the nuance that this law proposes. It's our goal today to try to provide some clarity, but I realize that each instance is very particular. And I think, just to reiterate Arlene's earlier suggestion, that one really does need to seek their own legal counsel to dive through a lot of these case studies. And so that's part of the challenge, is that this is a new law and the precedent around that new law is still forming. I did see also a couple comments. I don't think, Arlene, you were suggesting that artists should be volunteers. I think you were, correct me if I'm wrong, but you were just suggesting that nonprofits can actually have volunteers who are paid stipends, and that is not true of a for-profit company.
Right.
Obviously,
right. There was a question, for instance, if you have a community band, and that I think the facts were that they were only paying about $10 per person. This was their practice before, and can they continue to do that? And the answer, generally you should be able to continue to do things like that. I'm not encouraging people to not stop paying their workers. That's wouldn't be very equitable.
No. Could you speak? There are a lot of questions about the stipends and honoraria of, not just maybe volunteers, but are there any other instances where a stipend or honoraria might be appropriate? So many of us have guest speakers and guest artists coming into classrooms, and we want to compensate them. That's obviously a core value of making sure artists get paid a living wage. Could you just maybe speak a little more about instances where you could imagine that somebody could be paying a stipend or an honoraria in lieu of entering into a contract or determining they're an employee?
Right. Well, I guess, you could think about whether the person who's coming in is within your core business. There's a possibility that maybe it can satisfy the ABC test. If you're not telling them what they have to say, and it's not your core business, that might be a possibility. There's also that masterclass exemption. That might be a possibility. So you kind of have to think creatively about what there might be.
Right. I seen another question we have about if you can get state advanced approval for an independent contractor who, in this case, this is a question from Kevin Patterson, who they feel meets the ABC test. So it's a question about getting state advanced approval for an independent contractor.
Well, I don't think typically you would ask so there is something called there are opinion letters where they some questions are presented, and then the Department of Industrial Relations may provide an opinion letter, but typically I wouldn't recommend a individual to do that. Usually it's a lawyer who's representing a client who's trying to get the advice. It's probably the easiest way would probably be to talk with an attorney. There are some resources. I saw some people saying they can't afford lawyers. There are some resources out there, like there's California Lawyers for the Arts, which can provide low bono or referrals to pro bono attorneys. So that might be helpful. And then you can also try to, you can try to figure it out on your own if you can't.
Yeah. I also see a few people have asked how can they get involved in changing the law, and I will just make a plug for our partners at Californians for the Arts, and then their C4 equivalent California Arts Advocates, who do take legislative positions and have worked on some of these amendments and exemptions. The California Alliance for Arts Education, we're specific more in the arts education space, but we work very closely with Julie Baker and those partners on other legislative matters in the state capitol. And I would recommend getting involved with them. I know they're doing a great amount of work on AB 5. Some of these exemptions are in large part due to their advocacy in Sacramento. But obviously, as this law has come into place, there's been a lot of unintended consequences to our sector. And I think what we're hearing a lot in the chat, Arlene, is, our sector has been historically undercapitalized. And I want to point back to the Hewlett report with the Urban Institute and the Center for Cultural Innovation, because I think that report does a really great job framing this issue, because it was intended to give workers benefits and the pay that they deserve. So to this point that artists should be paid a living wage, I think the intent, and remember, in good racial equity work, we realize that intent and impact are two different things. And I think in this instance, I think some legislators had good intent to create a better labor environment for gig workers, generally speaking. It was initially inspired by Lyft and Uber drivers. And then the impact has been that there are some very not foreseen consequences to those of us that are now in the place of implementing these laws. But I would recommend everybody really take a look at that report, because I think it starts to look at the bigger issues within our sector about why we're undercapitalized and why we're under-resourced. And I think there is a spirit here that we're trying to make sure people get the wages and the benefits they deserve, because gig workers were often shortchanged by not getting health care, not getting workers' compensation insurance. So it's a complicated issue. And I realize those of us that try to do fundraising or have to come up with the resources to solve and meet the new legal obligations, it's a big lift. And we're not in a great position, especially during a global pandemic where many of our performing arts venues are shut down. Well, all of them have been shut down for a year. Most visual arts institutions the same. So, by no means do we want to say that this is a simple challenge, but I think the Hewlett and Urban Institute report does a great job trying to look at this from a long-term perspective about, is this a good thing in terms of helping get the living wage and the benefits we want to see for artists and arts educators. It's complicated because we're not there and we don't have the resources right now in many instances to respond. And so we are having to weigh out our mission aligned goals in terms of the work we want to do with the benefits that we want to provide our working artists and teaching artists. So certainly not a simple challenge. Going to some of the other questions, Arlene, and there are many. There's a lot of questions about festivals and seasonal work. And I'm wondering, if there's anything you could speak to in terms of seasonal employees or seasonal structures that might build some efficiencies in making sure that we're compliant with AB 5 and those organizations that might be doing seasons or have people who are coming back to work at different times in the year.
So there's no exemptions for temporary or seasonal work. So it's still going back to those tests that I showed earlier regarding that ABC test and whether there are any exemptions that apply. So unfortunately, it doesn't have that. I do encourage people who have to have a payroll company, and so that you're not doing it on your own. And there are, some people have been trying these PEOs, the organizations that try to help to offload some of the HR functions onto another organization to handle those expenses. That might be an option. We did get a question about if there's been a lot of enforcement for arts organizations, and I really haven't heard too much about that. A lot of this is coming, a lot of the cases that come up are really coming from an employee, or maybe there's a plaintiff's attorney who is representing an employee, and they'll typically, trying to go for the deepest pockets. So I think smaller organizations are not as much of a target, but that's what I've been hearing so far.
Right. I think that's an important point, Arlene, is that this is a risk assessment. There are laws that are on the books, and the question is sometimes about enforcement. And so obviously it's about, assessing your exposure to risk as an organization or as an individual, and then kind of navigating how you're mitigating those risks. On a different note here in the Q&A, we're hearing from Andrea Custer about the music industry exemptions. And Arlene, I'm just wondering if you could talk to, how those came about or what you may know about them. I know those are newer and kind of a little more nuanced, but I'm just wondering if there's any lessons we could learn about the music industry's advocacy that led to these exemptions and what you may know about them. And in this instance, it's specifically a question about, can artists do a lesson teaching music for a school as an independent contractor?
So I do know with the music industry, so initially with AB5, from my understanding from hearing Julie Baker speak about her efforts in lobbying, was that industries that have their own unions, such as actors and musicians, really wanted to try to ensure that as many people are classified as employees as possible. So there weren't very many exemptions, but then now with AB 2257, there was some lobbying and discussions with the music industry, so they implemented a lot of exemptions related to music recordings and some other of the music issues. So that's generally, you have to look through the statute in detail to look and see if what you're doing might apply.
Yeah. I'm seeing a large number of questions related to financial impact. Again, to this point that small budget organizations or sometimes all volunteer run organizations just don't have the resources to comply. Arlene, I'll give you a second to think about this while I'm speaking of some of the resources we've found, but I think just where can we look to find the financial resources to make sure we are fully funded and fully capitalized to make sure we're providing a living wage to artists and arts and cultural workers. I can say that for the California Alliance for Arts Education, as we've gone through this work with Arlene, and Arlene's been incredibly patient for all of the similar questions we've asked, similar to what we're hearing today. And then just the reality of how do we find the resources to pay for these increased costs of benefits and other things to get into compliance. Something we've done is for those of us in fundraising, we've made very clear to our funders, particularly those in the foundation space, that this is a real cost to us and that it's a cost that we feel is aligned with the value of paying artists and teaching artists and contractors as well a living wage. So I would encourage everybody to make sure in your fundraising plans or as you're looking at ahead the best we can in a global pandemic with a lot of challenges, both economic and in terms of health and operational, to make sure we're planning for these expenses, making sure you're building out your benefits programs and communicating that need to funders. So we've tried to all of our foundation partners make very clear that, we've in many cases asked for additional funding to see if those foundations could meet us to help make sure we're getting into compliance. And some have been quite responsive. So we've also found that responsiveness from individual donors when we explain, hey, we have some increased labor costs, or in conversation with individual donors to explain that there are some legal compliance issues around labor law in California that we're trying to be compliant with, and that there are some increased costs related to that. But Arlene, other than California Lawyers for the Arts, who I know is a great pro bono legal referral project, are there other resources, financial or legal, that you could recommend?
I don't have too many. I mean, many bar associations have legal referral. Like the San Diego County Bar Association has a legal referral information service if you're looking for an attorney, but it's not pro bono. Or sometimes there are some like volunteer lawyer organizations that may be in your local community that may be able to provide assistance as well. But unfortunately, I don't know a lot of ways to get around it.
Yeah, and we're hearing that some people are saying California Lawyers for the Arts were pretty swamped with requests related to AB5 and didn't have the capacity to support everybody. So, I do recommend on the advocacy front, Californians for the Arts is doing a lot of advocacy. Lorena Gonzalez, Assemblymember Lorena Gonzalez, I think has been very open to making sure that the legislature understands these challenges related to the implementation of AB5. That's how we've got the exemptions. I think, to your point, Arlene, those industries that are more resourced from the union infrastructure, like the music industry in this case, and frankly, music's been a better organized and better resourced discipline. And I think we should look to music as a kind of a value for those of us working in dance and theater and other aspects of the arts where we've maybe not had the same infrastructure or the same capacity to be looking to their example in terms of organizing and coordinating and working across coalitions to make sure we're advocating for our needs, both in terms of labor rights, but also in terms of our sector of nonprofit arts and culture. Well, we just have a couple minutes left. I'm going to try to find a couple more questions. There are a lot of them. There's a question here to discuss SB 805. I'm just learning this about this from Julie Baker with Californians for the Arts, and we will be looking into it more. I don't know if Arlene, you've heard anything about SB 805 or have any insights in terms of what impacts this may have on AB 5?
I don't know. I don't have anything to say about that. I'm not sure what that one is.
Well, I will say it's here in the chat. Thank you to Elizabeth Santana, who has put in the chat a link with some ledge info. So for those looking for more information or wanting to get involved in that advocacy effort, you can look here in the chat. Let me just cut and paste that again so that it's current in the chat, but there's some more information there. It's, whoops, I cut Californians for the Arts, but we'll add that into the links that we send out. But that's a real-time advocacy effort. And if you're motivated after this conversation to get involved, that would be one of the bills to be watching, because I do understand that there's an opportunity for some additional exemptions for the arts and culture sector. Let's see. There's a good question here about, is there an FAQ resource of some kind that views AB5 through the live performing arts lens, or other written resources, Arlene, that people could go to online that you think are beneficial or valuable?
So there, I don't know if I can put it into the chat in time, but if you look at the Department of Industrial Relations, and they do have FAQs on independent contractors where they summarize independent contractors. I think we also have a slide that lists some resources. So maybe we could go back to the slides. There were some resources there that we were going to put in to the chat as well. Lorena Gonzalez, who is the author of AB5 and AB 2257, she has a fact sheet, and I have the link there. So you could take a look at that. Californians for the Arts has a number of resources and other webinars about the issues. So I think that this is the basics that you're going to want to take a look at. We also did have a question about someone's trying to figure out if they're going to be an independent contractor and what kind of legal requirements they have if they need to get a business registration. And there are some resources from the state talking about what you need if you need a business license, a fictitious business name, filing with the Secretary of State. I've forgotten now what I can send out, maybe if we have a follow-up email, I can send out that resource, which shows there's a resource that shows you what kind of licenses you might need for certain businesses. So that may be helpful as well.
Great. Well, thank you, Arlene. I'm seeing we're just about at time, and so I just want to see if, Arlene, you have any final closing remarks. We want to thank you so much for your partnership and your time on a very complicated issue. And I know we'll have ongoing questions for you, but just really appreciate all of your thoughtfulness and to your own volunteer service in the sector of arts and culture, because it's meant a lot in terms of how you viewed our work and being very patient with us to getting into compliance. But just give you an opportunity if there's any last words you wanted to share with everybody.
Sure. Well, thank you, everyone, for your time. Please feel free to reach out to me if you have any questions going forward. And I do a number of speaking on different issues. We're going to be talking about free speech issues related to employees coming up in a couple of weeks, and then also about talking about return to work issues. So if you'd like to get onto my firm's mailing list to find out about other webinars, feel free to reach out to me. But thank you very much for your time.
Great. Thank you, Arlene. And then just two last final opportunities. For those of you that want to learn more in arts education advocacy, the California Alliance for Arts Education, Create California, and Arts for Los Angeles is hosting a webinar on the local control accountability plan process This is related to school board advocacy. And we have an upcoming webinar here at the link on Wednesday, March 17th. This will give you some tools for those of you that are really fired up today about wanting to get more involved in advocacy. This is geared towards school boards and arts education, but some of the lessons are very relevant to taking on state level advocacy. Much of it's transferable to advocacy in general, but this again will be specific to school board advocacy and the LCAP. And then there is a link we will place in the chat, the Employment Law and Freedom Speech link, just as another research resource that is coming up on Tuesday, March 16th from 10 to 11 a.m. So again, thank you so much, Arlene, and thank you to Californians for the Arts for their partnership, and to the Walter and Louise Haas Fund and Francis Phillips for helping resource this work and for your resourcing it across the field, not just with our organization, but many arts and culture organizations who are struggling both to get in compliance and understand the law, but also during a very difficult time. So thank you for everybody's service and great leadership in the field, and for joining us today. This has been one of the more popular webinars we've done, with almost 200 people joining us today at the peak. So clearly it's a very hot topic, and we will continue to monitor things in Sacramento and do our best to create a pathway forward so our work can continue with the good work everybody's doing. So thank you for joining us today.